of time, from Jefferson's presidency, which commences in 1801, to the presidency of Lincoln, which would commence in 1861, I argue that there is no more iconic figure than the fugitive slave. The fugitive slave was positioned precisely between the 2 points that had made the American Revolution at once so spectacular and at once so horrific. Because it was, of course, in the American Revolution that we see that universal claim of freedom, which at first is embodied abstractly by the Declaration of Independence, and very shortly after would be solidified in the Constitution. And of course, very noticeably, in two particular claims of the Constitution, which we still hold dear today. First, the protection of habeas corpus, which we can find in Article 1, which says very explicitly that Congress will not suspend the writ of habeas corpus except in times of rebellion or invasion. And then also the Sixth Amendment, which guarantees us trial by jury in criminal cases. Now, these protections, these constitutional protections, were stronger than that applied in any other government at the time. Yet the same Constitution also brooked compromise with slavery. And at very important points in the Constitution, slavery was not only protected, but explicitly sanctified. And most noticeably for what I'm talking about, Article 4, Section 2 of the Constitution stated that any person held to labor, which of course was a slave, would not be free if he was to escape into a state, where slavery was not allowed, but instead would be delivered back to his master. In other words, slavery would be protected even in those states where slavery had been outlawed. The wonderful irony of the period between Jefferson and Lincoln is that at the same time that democracy is really sowing its oats, in other words, just at that point when democracy is becoming more democratic, as the republic is transitioning from being the province of elite white males to something far more democratic. You see, for instance, the elimination of property requirements for voting during that time. Slavery was itself intensifying. And nothing would upset slaveholders more than the fugitive slave. Because it was at once this fugitive slave who was trapped in this dilemma of being born into a system of slavery in a country of freedom, who typified at this time all that could be American in his aspirations. He sought nothing more, and she sought nothing more than freedom. And they were willing to move from the conditions that they found themselves born into in order to find freedom elsewhere. And this is the story of Joshua Glover. He was born in Missouri in 1852. In 1852, he left Missouri. He wasn't born in 1852. In 1852, he left Missouri. He went from Missouri to Wisconsin, where he settled with the free black community there. His master, a man by the name of Benjamin Garland, pursued him, and after learning that he was outside of Milwaukee, had him arrested. Glover's arrest was first trumpeted, as occurs on March 10th, was first trumpeted by abolitionists the morning after it was discovered. And so, on March 11th, abolitionists called a general meeting to address what had happened to the fugitive slave. And at this point, they only knew that a fugitive slave was in the Milwaukee jail. And I certainly get this impression. If you think about what a fugitive slave rescue might entail, I think most of us would probably get a sort of Mel Brooks image of, the mob gathering and then immediately breaking into the jail, breaking out the fugitive, probably burning the jail down, and then robbing the dry goods store on the way out of town. One of the things that had struck me about this rescue was exactly how it commenced. It began at 1 o'clock in the afternoon when 5,000 people assembled in the square, courthouse square outside the jail. The first thing they did was elect a president. The president then appointed a committee that drafted resolutions. This took about 2 hours to complete because they kept coming back to the crowd with the resolutions and reading them, and people in the crowd would actually call out revisions that they wanted, votes would be taken, and then finally, this is from 1 to about 3 p.m., they agreed on a set of resolutions which stated specifically that they would stand by this prisoner, being Joshua Glover, until his right of habeas corpus and his right to a trial by jury would be respected. When this was presented to federal officers, the marshal who had him in custody and the federal judge who made his office in the courthouse square. They refused to follow the writ of habeas corpus that was presented to them. As a result, the crowd then began conversing about what to do next, and after being counseled against violence, then decided to take matters into their own hands. And it's precisely at that point that we see the rescue happen, a full 5 hours after the rescue actually had begun. In other words, after the crowd had actually arrived. So here is the rescue. It takes place on one afternoon, March 11th, in 1854. What is probably most dramatic about this tale, and there's a lot of drama to it, is what happens afterwards. Because in Wisconsin, the fallout from the rescue was indeed spectacular. First of all, you have the federal government. You have the officers who were charged with enforcing the Fugitive Slave Act. You have the judge who there had explicitly refused to obey the writ of habeas corpus that had come from the state court. And you had, of course, the slaveholder, who was now holed up in the offices of his attorneys, fearing for his life. They were very, very unhappy about the fact that this fugitive slave had been rescued. And they immediately commenced prosecution of all the people who had been involved. Now, there were several thousand in the square. They picked only the loudest of the abolitionists to actually prosecute. What happens over the next 5 years is truly remarkable. First of all, a jury would convict the lead abolitionist, a man by the name of Sherman Booth, not of rescue actually, but of removing the prisoner from the federal marshal. He would then ask the Wisconsin Supreme Court to intervene, and the Wisconsin Supreme Court did. In 1855, it not only freed Booth on a writ of habeas corpus, it also issued a ruling declaring the Fugitive Slave Act of 1850 unconstitutional. And that, I haven't spoken here about the Fugitive Slave Act of 1850, but I mentioned that the Constitution provides that fugitive slaves will not be freed. In 1850, Congress passed a law that suspended the writ of habeas corpus for anybody accused of being a fugitive slave, which meant that if you were a slaveholder, all you need do to claim a fugitive slave would be to go to a court, say that you had actually had a slave run away, get a description, go to where you say the fugitive is hiding out, pick him up or her up, take him to court, have your little writ stamped, and then you are fully authorized to take this person across state lines and reduce them to slavery. The obvious problem here, and it's pointed out in 1850, 1851, and all the way through 1860, is that there is no protection for free blacks. There is no attempt in this law to give free blacks who might be picked up as fugitive slaves any kind of representation. And the writ of habeas corpus, which could be issued by a state court to check and see if a free black had in fact been mistaken as a fugitive slave, was suspended. So the Wisconsin Supreme Court, when it reviews the law in 1855, finds it unconstitutional. Now this begins another round of actions which will occur in both the Wisconsin court and the United States Supreme Court. As you can probably imagine, the U.S. Supreme Court is not happy about this. The Chief Justice is Roger Brooke-Taney. And for those who don't know who Roger Brooke-Taney is, he was from Maryland. He was inordinately pro-slavery. He is the author of the Dred Scott decision, to give you an idea of who he is. And so he immediately requests the record for review from the Wisconsin State Supreme Court. The Wisconsin Supreme Court refused to send the record up for review. In other words, it tells the U.S. Supreme Court that it has no authority in this matter. Now this, although it was actually not an isolated event in early America, in fact we see a lot of resistance to the United States Supreme Court at this time, it had never been over an issue so major. And the U.S. Supreme Court would for 5 years not receive the court records in this case. The state of Wisconsin went even further. In 1857, they passed a personal liberty law. It made it the duty of every state officer, and that is from every sheriff to every justice of the peace, right up to the governor, made it their duty to see that any who were arrested as fugitive slaves would have all the representation necessary to defend their positions. In other words, if they turned out to be free citizens of the state, they were to receive all the protections that state officers could afford. In 1859, and this is 2 years, by the way, after Dred Scott, and Dred Scott, I probably should, for those who may not recognize the case right off the bat, Dred Scott is Taney's famous decision where he declares that anyone of African descent in the United States cannot be considered citizens of the United States. So fresh off of this, what was utterly disastrous ruling that he issues in 1857, he reviews the case from the Wisconsin Supreme Court in 1859. And he does it without the record and without any acknowledgement from the Wisconsin Supreme Court whatsoever. He overrules them, says the Fugitive Slave Act is constitutional, despite the fact that it suspends the writ of habeas corpus, and orders that Booth be rearrested, that the abolitionist who was charged with the rescue. In response to this, the Wisconsin legislature passed 2 resolutions. They pledged eternal constitutional resistance to this decision of the United States Supreme Court, accused them of usurping what belonged to the states properly, and then finally invoked the Kentucky and Virginia resolutions, which is this wonderful Jeffersonian statement of how the states are sovereign, and the states, and this is what may not first come to mind when we think of northern resistance to slavery, that it is the right of the states, in other words, it is the states' right to resist slavery on the basis of its sovereignty. This nearly brought Wisconsin and the federal government to blows. In 1860, this is right before the election that will propel Lincoln to the presidency, the arrest of Booth led to another rescue and then would lead to a governor's order that the militias ready themselves in case the United States Army be called out to enforce the Fugitive Slave Act. The one militia company that responded saying that this was an unconstitutional call by the governor was quickly disbanded by the governor. So in 1860, you can imagine this, here we are, we're not in a presidential election year, but if you imagine February, March, April rolling up in the time before a presidential election, it looked to very many people like Wisconsin was going to be the first state, not just to challenge the United States and its relationship with slavery, but very possibly to secede. So the first real threat of secession is now coming, in the time before the Civil War, is coming out of Wisconsin, and not at that time from South Carolina. Now, the election of Lincoln alleviates this. And in fact, you see the Wisconsin Republicans start to slowly pull back from the idea of states' rights during the Civil War. But throughout all of this, and you think about this for a minute, if we back up and think about the story that we start with, the story of the fugitive slave, the story of Joshua Glover, who finds himself born into this system, who finds himself wishing only for freedom, who finds himself being caught in this American irony of slavery and liberty existing under the same constitutional system. His initial arrest and rescue had prompted what was really, by all accounts, the worst constitutional crisis that the United States had seen and would see until the southern states actually did secede very shortly after the election of Lincoln. The fact that he is at the center of this, and a fugitive slave, is what could precipitate such a tremendous struggle. The fact that his ironic condition would be something that could precipitate this immediately raised questions. And I'd like to stop here with talking about the narrative and actually talk about how I came to the project, because I think that story actually might help elucidate some of the themes that I ended up picking up on. This project, which began in Milwaukee, did not start as a study of the fugitive slave rescue. I was at the time a somewhat younger graduate student at UCLA, of all places. And I had come to Milwaukee to study, and I'm not kidding, tort law and industrial growth in the Midwest in the period between 1840 and 1900, which is a wonderfully academic subject that never would have gotten me invited to the Margaret Mitchell House, and very probably rightfully so. And I was in the middle of archival research that took me about 4 or 5 months, and I compiled a database of over 2,000 cases, all related to industrial accident claims. And I had a crisis. This was the most boring thing I had ever done in my life. And I had done it for 4 months. And had done it willingly. It was very frightening. But the crisis, I realized, was nothing really to do with the subject. It had to do with my relation to the subject. Because I couldn't find anything in this story, industrial tort law, in Milwaukee in a developing industrial economy. I couldn't find anything of value there. I couldn't find anything of meaning. The rescue of Joshua Glover came to me by surprise. I was speaking with one of the archivists, and the archivist introduced me to the story. The story captivated me. I was struck immediately by questions that really defied any kind of simple answer. Why, for instance, would people gather outside of the jail? And Milwaukee was about as close as you could get to a cosmopolitan city in 19th century America. It was actually majority German. 60% of the residents were not just German-born, but still German citizens. They were American aliens. The white Americans who had moved there, or Native Americans as they're sometimes called, were largely Yankee, coming from New York primarily, some from Massachusetts. These were the majority of people who turned out in the thousands to see what was happening to a fugitive slave. Why they would connect with this was an immediate question I had. Another, of course, was why, once they were all there, they actually waited around to elect a president and settle on resolutions and try to go about getting the slave released legally. And finally, I was very interested in what role Milwaukee's very small African-American community played in the rescue. They were not mentioned in the sources, and they would not be mentioned, for the most part, in the political debates that were so important in Wisconsin after the rescue. These questions raise, and I think it's even more true now, it raised very disquieting questions about how people in the 19th century thought about citizenship. What did it mean to be a citizen? And for that matter, for somebody like Joshua Glover, who could not ever claim the title of citizen, not because he was black, and they make this clear, because part of the debate they have to have in Wisconsin is what rights do blacks, whether they be free or fugitive slaves, have in Wisconsin. And they make it very clear in Wisconsin that they have plenty of black citizens who enjoy virtually the same rights, certainly all of the same protections that white citizens in Wisconsin also have. But why would they gather? Why would so many gather who had possibly no stake in this fight, to find, not just to find out what would happen to a fugitive slave, but then to actively take a part in protecting this person's rights? How could Joshua Glover then become the center of what would be the constitutional storm that would precipitate the Civil War? And finally, and this is something that was magnified by all the political debates that happened afterwards. We have 5 years of wonderful electioneering that will go on in Wisconsin between 1854 and 1859, actually right through 1860. And the rescue of Joshua Glover becomes a flashpoint. It becomes a way for people to articulate not only what they mean about citizenship, but also what it is that they mean about race. So how these two things were colliding, how they were reconciled, is very much the subject of my book. Now, I want to open the floor actually for questions. I didn't want to talk too long. I'd rather find out what maybe people either didn't get out of my talk or are interested in more. So at this point, I'd like to open up the floor and see if anybody has any questions. I'd be happy to talk more about the themes if that's what you'd like me to do. But
strictly speaking, from a law standpoint, what right did the Wisconsin Supreme Court have to outlaw something that was already in the Constitution?
Okay, the question was, from a legal standpoint, what right did the Wisconsin Supreme Court have to outlaw something in the Constitution?
To declare it was unconstitutional.
That's a wonderful question, and there's several things that qualify this. We are fairly used to today thinking of the Supreme Court as the last arbiter of the Constitution. Whatever the United States Supreme Court says the Constitution means is what the Constitution means. This position was not accepted in the 1850s. And no decision makes this more clear than the Dred Scott decision. And the real meat of the Dred Scott decision is actually the pronouncement that Congress cannot prevent slaveholders from taking their slaves into the territories. And this is one of the real big issues going into the Civil War. And when the Supreme Court says this, which is supposedly going to restrict what Congress can do, most people respond by saying, well, the Supreme Court's dicta has no bearing on what Congress will do. We do not accept, in other words, the constitutional pronouncements they make. So the Supreme Court was not really a constitutional authority the way we think of it today. Now, the Wisconsin Supreme Court, by taking the action they did, was really taking an unprecedented step because they were the first court to come out so strongly against the federal law. And the decision is really remarkable. I have two chapters where I analyze, actually I have one chapter where I analyze that decision in particular. And that decision was based on three main points. They say, first, Congress had no right to suspend the right of trial by jury. They had no right to suspend the right of habeas corpus. And third, and this is a little more arcane, they appoint these court commissioners to process the claims, and that's not a legal office. So those are the three bases in which they use to actually declare the Fugitive Slave Act unconstitutional. They don't declare that fugitive slaves are not to be returned. They disagree on the procedure by which you can actually claim that somebody is a fugitive slave. And they say the Fugitive Slave Act does not do this. And this is what gets complicated, the actual points legally that they rest on are fundamental to questions of citizenship. There was really nothing that we could consider U.S. citizenship at this time. You were a citizen of the state that you lived in. And so what the Wisconsin Supreme Court was doing, fundamentally, was saying, the citizens of Wisconsin look to us to protect their liberties. They do not look to the federal courts. And therefore, the federal courts in this matter have no jurisdiction. So they're making a point about citizenship, and of course that will be changed by the Civil War, because the 13th and the 14th Amendments passed in 1865 and then again in 1868 for the 14th would nationalize citizenship. And that creates a completely different role for the federal courts.
So how could, the Constitution says that the right of writ habeas corpus won't be suspended except in rebellion or invasion. The Civil War hadn't started. How could Justice Taney or anyone else say that a law that does that is constitutional?
Oh, that's a great question. The question is, if the Constitution says that you cannot suspend the writ of habeas corpus except in times of rebellion or invasion, how could Justice Taney say that the Fugitive Slave Act of 1850, which suspends the law, is constitutional? The answer is actually very simple. He just says it's constitutional. He does not explain it. His decision is all the decision's long. It's multiple pages, but the part where he talks about the constitutionality is one sentence, and he just says, we find this law constitutional in all its provisions, and the Wisconsin court is wrong. The Wisconsin court opinion ruling the Fugitive Slave Act unconstitutional is about 100 pages long. He ignores all of it. He dismisses it in one sentence. So it's a great question. I wish Taney were here to answer. He might actually provide more insight into what he was doing. Bottom line is he was somebody who was pro-slavery. He believed that the Constitution. He not only believed that the Constitution sanctified slavery, he also believed that blacks, whether free or not, had no role in the United States, and that position dominates much of his jurisprudence.
Personally, I'd like to hear more about your themes.
Well, one of the question more about my themes. One of the questions that comes up, and I've skirted it a little bit here. It's easy for us to be upset with people like Chief Justice Taney. He was a slaveholder. He was somebody who is a very easy target for us now. It's a little less easy for us to take very seriously those people in Wisconsin who sat down to begin debating what to do about the Fugitive Slave Act and their resistance to it. Northern United States, the northern states, those who would, particularly in the old Northwest, states like Indiana, Illinois, Wisconsin, to a less degree Michigan, all the way back to New York, Massachusetts, and the old northern states were notoriously racist. Notoriously. And this is something that really did strike me with great force, because how is it then if you have this overwhelmingly racist society, the number one form of entertainment by the way, during this time, and I devote a chapter to this as well, the number one form of entertainment is minstrelsy. The minstrel troops that entertained the country. This is kind of like our modern day movie theaters in a lot of ways. The minstrel troops were these white troops, acting troops, singing troops, who would put on blackface and then go from town to town, and they would go to a theater and they would perform plantation songs. And they were supposed to be authentic plantation songs. They were all written by whites, and they would dance around, and then they would tell jokes, and they would all be, obviously racially inspired jokes. And this formed the bedrock of popular culture in the North. Horribly racist. And in fact, the minstrels arrived in Wisconsin shortly before Joshua Glover was found in the jail. And right after Joshua Glover left, another acting troupe arrived. But this one came performing Harriet Beecher Stowe's Uncle Tom's Cabin. So now you have Uncle Tom's Cabin arriving. And here you have a much different view of both slaves, fugitive who run the George and Eliza story in Uncle Tom's Cabin, and of course Uncle Tom himself, the martyr who was sold downriver and ultimately killed as a slave. What I found was that nobody really knew who Joshua Glover was. They talk about him a lot, and this probably won't surprise us if any of us are used to reading the paper and talking or seeing the way people talk about political figures. Joshua Glover is talked about quite a bit. But within weeks of his disappearance, everybody's talking about him as if he was a character in Harriet Beecher Stowe's play, or as if he was one of these minstrel characters who arrived. In other words, they began filling in the details of Glover's life and his character by what sort of popular culture references they see and know. So by the time we get to 1857, Joshua Glover has completely disappeared. And in his place is this caricature formed out of what people's racial suppositions are. And frankly, not very many of them are positive. But still, and this is the conundrum for a historian, still, you have a good number, a majority of Wisconsinites who are willing to go to the polls and stand up for Joshua Glover's rights. And then, of course, as well, for the rights of any other fugitive slave who's found in Wisconsin. And they keep this resistance going despite tremendous adversity. The stakes are enormously high. If we think that politics have gotten bad, and they have in a lot of ways in our current time, we don't have anything on the 1850s. This was a really, really bad time to be around. And expressing the wrong political opinion could get you tarred and feathered. There were certain places you simply did not go if you were of a particular political persuasion. And the rhetoric is enormously bad in the newspapers as well. So here we have a very tense time. And remember, the Union is splitting apart. And everybody is aware that the Union is splitting apart. So at this moment, for people to stand up the way they did is really extraordinary.
Whatever happened to Glover?
The question is what happened to Glover. Glover ends up in Canada. He ends up in Ontario. And we have census records of him, so we don't know much, but we know that he arrives in Canada, he settles in Ontario, and he will live there until, the date will be correct in my book, but I believe it's 1882. And he lives the rest of his days in freedom.
I'm very curious about the crowd, the people who went to defend him. They were racist, they were defiant. But what else were they? Were they the professionals of the town? Were they educated?
Question being, who was in the crowd, basically? Who was there? That's also a great question, and that's what I first turned my attention to. And the way that I did this was I looked at the committees that they set up. So the president they elect is a man named Wolcott, and Wolcott is a doctor, he's a professional in the community. He's also a militia general. And the committee that they appoint consists of 2 people from each ward in Milwaukee. So you can see they've already tried to create a democratic committee that will represent the city at large. And that meant, of course, having Irish on the Irish 3rd Ward has to be represented, so they have 2 Irishmen. The German 2nd Ward, yes, the German 2nd Ward also got 2 representatives. There were prominent abolitionists as well on this, almost all from the professional classes. The makeup of the crowd itself was much more diverse. There was a cathedral being constructed at this time, And the cathedral was right next door to the courthouse square. It's where the marker is today. If you go to Milwaukee, you can see the marker that indicates where the rescue took place, because the courthouse has long since moved from its original location. And the church is also still there, and there were a number of laborers there working on that very cold morning on the church. And so they all came over as well. We don't know what the whole makeup was, but we can clearly tell it comes from all classes. And the newspaper editors make note of this. They say over and over again, and the language is wonderfully idiosyncratic, all kinds of people were there, Americans and the Irish and the Germans. So you know immediately that who the Americans really are. They're gradations of white that exist in the 1850s in the United States. And very much they're conscious of that. And they're also conscious of the fact that at the center of all urban unrest in the United States, and I'm emulating a viewpoint here, this is not my viewpoint. At the center of all unrest, you will find an Irishman. You will find a German. You will find an immigrant who doesn't understand democracy. So when all these people show up in the courthouse square, they are enormously concerned that this will turn violent. And the fact that it doesn't, they love. The editors keep harping on it. They were sober. They mentioned this. They were sober this crowd. They didn't commit any other damage. And in fact, in the trials afterwards, they go through this wonderful list. What kind of damage did they do? Well, they broke the door, and that cost $15 to repair. Any other damage done? Nope. No windows broken. No general mayhem. They didn't release any other prisoners. It was a very ordered mob. Yes.
Well, I will assure you that I'll read a book, but it's so fascinating. I want to know the African American. You said there were a tiny community of African Americans. What role did they play in all these events?
What role did the African American community play in this event?
If any.
In the rescue itself, there's a disjunct that goes on. They're not mentioned at all. It is almost impossible to confirm that one member of the African American free black community in Milwaukee took part in this rescue at all. And that is surprising, because I suspect they did. I don't know if they did, but I suspect they did. And most people now simply assume that they did. They certainly take place in the politics afterwards. And this is made note of by Democrats. The Democratic Party is the pro-union, pro-South party during this time. And the Democrats note that when the anti-slave catchers meeting first takes place in April, only 2 months after the rescue, that they list all the people in attendance. Well, they list the numbers, and then they say, and there were a certain number of blacks there as well. And then actually one editor proceeds to make fun of them, which I talk about in the book. It's a terribly interesting moment. There were very few people who could be politically active in the free black community. One notable man was a man by the name of Nolan. And this largely because he was so incredibly well-versed, well-read, was very well-educated, he was able to really slip under the radar. He did various jobs, including running a hominy shop. He owned his own business. He was a barber for a time at the Capitol. And then he becomes an office holder. And nobody notices that he is an office holder. First of all, he can do his work out of sight, so nobody ever notices that this man is part of the government, the Republican government in Wisconsin. When they find out, the Democrats are furious, and they publish it everywhere. There's been this black person who's been holding an office in our city, and shortly after that, the Republicans, although they defend him, are forced to slowly back down from having him as an office holder. So they can't play too strong a political role. What they can continue to do, and certainly what they do in every northern city, is they continue to provide the underground support necessary for the Underground Railroad to continue operating. And that is more true in other cities than Milwaukee, particularly Cincinnati. Cincinnati's free black community was very large, and it formed a front line, especially after the race riots there in 1829. It was about every 5 or 10 years, the white community gets upset about something in Cincinnati and immediately goes to the black part of town and destroy it. And in 1829, formed defensive communities and fought back. And that formed that defensive community became a front line in the Underground Railroad. And it inspired, to use a common word, it emboldened many free black communities across the North to continue receiving fugitive slaves. So their role is more underground than it is political. But it is certainly worth notice today. And we also have to take notice of the fact that they do not talk about it at the political level back in the 1850s. Yes.
What was the population of that city compared to the amount of individuals that turned out at the front border?
The population in Milwaukee at the time? The population was, I believe, 50,000. So we're looking at a good number of people showing up. And remember, you got to break that down right away into families, because of that 50,000, you can have a certain percentage that are children, and then women were not present at this event. It was only white males. So, yes.
No, I was just trying to ask you to call upon this.
Oh, okay.
Right.
Thank you.
He's been trying to get them to...
Yeah, no, I figured, so I call him. Thank you. Harry?
Yes. My question is about the cost of enforcing the Fugitive Slave Act. Who was responsible for shouldering or for covering the cost? Was it the local government, the federal government, and perhaps could someone argue that the state of, perhaps was Wisconsin, for instance, arguing against the enforcement of the Fugitive Slave Act because they felt that the cost of covering that responsibility would lie squarely with the state?
Question, briefly put, who shoulders the burden of paying for the Fugitive Slave Act? Which is a wonderful question. And the answer is not static. It changes over time. What we see happening with the United States government is this. In the Constitution, and if you read very carefully what the Fugitive Slave Act says, it doesn't say anything about giving Congress the responsibility of returning fugitive slaves. It simply says that fugitive slaves must be returned. Must be returned from one state to another. The federal government passes a law in 1793, and the law that they passed, the first Fugitive Slave Act, leaves the burden on the states. So it's the states that are really returning fugitive slaves right up through the 1830s. And if you think about this on a timeline, the 1820s and the 1830s internationally is the great period of abolition. This is when abolitionists in Britain will succeed in getting their plantations to abolish slavery. And it goes through an act of parliament. And when this happens, it occurs between 1829 and 1832, it inspires the abolitionists back in the United States. And they end up also pushing for abolition. They can't get it done in Congress, so they go to the states. And the states begin withdrawing their resources that make it possible to return fugitive slaves. Quite literally, they close the courtroom door in many states, particularly in Massachusetts, which, if you're a slaveholder, this is a bad place to lose a fugitive slave to, because the courts just close their doors. They won't listen to a fugitive slave case, which means that you are now at great risk if you are a slave catcher. Because if you are going to try to carry somebody and they don't want to be carried back, so they're usually resisting rather violently, if you try to carry them back, you could be arrested for kidnapping without having a legal warrant to remove this fugitive slave. And this is one of the reasons that Congress passes that Fugitive Slave Act in 1850. Then the burden is shifted to Congress. And very interestingly, and here's another political lesson worth thinking about, enforcing the Fugitive Slave Act was very expensive. The most expensive case is the Sims case in Boston. It would cost the federal government $20,000 to take a fugitive slave from Boston, where he was found, all the way back to Georgia, which is where he was from. He was a stowaway on the ship that had landed in Boston. And the price of the slave at that time was somewhere between $1,200 and $2,000. So $20,000 the federal government will spend to return one slave from Boston to Georgia. One of the reasons it's so expensive, Boston crowds were out in force. And the U.S. Army, once again, had to be called out. In fact, the U.S. Navy was there, and they had a military escort for this slave to get him back. And so important was it to make a statement that they refused even the offers of the Boston Abolitionist Society, which offered to pay the slave owner twice the value of the slave. They would not accept that, and instead the federal government shoulders this tremendous responsibility. It had become a completely unworkable law, unenforceable in many states by the time we get to the Civil War. Yes?
Was there any vigilance committee in Wisconsin?
Was there any vigilance committee in Wisconsin? Yeah, well, actually, one of the committees that this crowd appoints is a vigilance committee. It's not a standing vigilance committee. You're thinking about the standing vigilance committees in places like Boston, particularly in the African-American communities there. African-American communities, I mentioned before, forming that front line, would appoint vigilance committees. And these vigilance committees would make sure that slave catchers in the area had not picked up somebody in secret. Now, in Wisconsin, the vigilance committee, which was appointed, I suppose kept going, but they don't keep any records, and it doesn't appear that they have anything else to do. And there's no other fugitive slave case after this one. There were ones before, and there were slave catchers abroad, as they continually say. There's slave catchers abroad in the countryside, but they don't make any arrests after the Joshua Glover incident.
I'd like to hear more about your big themes, too. I'd like to bring sort of race and citizenship together as we're talking about the Glover case. It sits in the middle of these two.
More about race and citizenship and how the Glover case brings them together?
And sort of a subsidiary question, if the Glover rescue has sort of national resonance, what does it play national?
And what resonance the Joshua Glover had nationally? The Joshua Glover rescue had nationally, excuse me. First of all, nationally, this would actually break out on the United States Senate floor. Senator Toombs from Georgia would stand up and accuse the state of Wisconsin of becoming rotten before she was ripe. That this state had stood down on its constitutional duties, and everybody in Wisconsin should be ashamed of themselves for this. And up stands Senator Doolittle, James Doolittle, from the state of Wisconsin, and he says to Senator Toombs, is it not true, sir, that your state defied the federal government back during the Chisholm crisis? And he says, that's not the same thing. We had a legitimate reason for doing that. And then he comes back and says, well, let me ask you this. If the Fugitive Slave Act of 1850 is unconstitutional, did not our court act correctly? And Toombs answers yes. He has to. Otherwise, he can't justify secession later. And then Doolittle adds, in this kind of wonderful 1859 way, I'm glad you said that, and your attitude, or no, it's not your attitude. I'm glad you said that, and the way you talk about Wisconsin had better change. To which Toombs replies, I'll meet you anytime, sir. So you can see the makings of a political duel already happening. This was a case that it's rather sad that this is forgotten today. It's not taught in the United States history narrative. It had tremendous resonance. In a lot of ways, it was more important than Dred Scott, because right in the period before the Civil War, this was the iconic case that the South was using to blame the North for the breakup of the Union. To talk about the larger themes, and I moved back once again to that moment of personal crisis I had where I wasn't sure any longer if what I was doing was of any value, which is why I abandoned industrial tort law. And I have nothing against industrial tort law, I promise. But why I moved from that into this, that question that I kind of reiterated about why would people stand up for somebody who they had no political stake in, brought me back to a theme that I found buried in the material. It was a legal theme, but it was really a constitutional theme. And it had to do with who really protects our rights. In our day and age, accustomed as we are to the way our polity operates now, and in a lot of ways conditioned by what we're taught about the civil rights movement, we tend to think of courts, after the very famous Brown v. Board of Education, as being that real defender of our rights. But they make it clear, time and time again, the courts cannot be relied upon. It was not the courts that would defend anybody's rights. It would have to be the people assembled. And this meant whether they were going to assemble outside of a jail and inquire as to why somebody was imprisoned therein, whether it was demanding that as they put it, the sacred constitutional rights of habeas corpus and trial by jury are observed for everybody, or whether it was going in 1859 to the polls to elect to the Wisconsin Supreme Court. It's an elected bench, by the way. I probably should have mentioned that. To elect a staunch states' right advocate who had written the argument declaring the Fugitive Slave Act unconstitutional as a lawyer at the time. These were all moments in which they imagined themselves doing something very important, where they really imagined themselves as being citizens. This is something I don't think we can lose sight of. And I don't think, particularly in our current political climate, we can lose sight of what was a major lesson of this time. If you are going to enjoy rights, any rights, then everybody in the community must enjoy them. If you are going to have protections, the protections must apply to the weakest and the most vulnerable among us. It is very easy to turn your eyes from those who are the most vulnerable. It was very easy for people in the North to do this to fugitive slaves. The people of Wisconsin didn't. And it wasn't just a rescue, and I want to make that clear. It was 6 years of sustained political fighting. Thank you.
To ask whether there was a perception within the United States, or perhaps from the Supreme Court, that these people from Germany, like you say, there was a huge German immigrant population in Wisconsin, whether there was this perception that this German immigrant population was trying to change what was considered a very vital law, the Fugitive Slave Act.
That's a great question. What about the German population, and was their presence there vital, or was there a debate about whether they were trying to change the Constitution or change the politics?
Yeah.
Yes, there is, and there's a wonderful problem with this in Wisconsin. Everybody, particularly the Anglo-Americans, the Native Americans, those who were born in the United States, who were also white, these people really don't like sharing their political power with the Germans, but by Wisconsin law, residency for a year entitles you to vote. So these Germans vote, and they come out to the polls in large numbers. And the moment people start getting nativist in Wisconsin, the Germans vote in blocks against them. So there's always a very strong voting bloc of Germans, less so of Irish because there were fewer in Milwaukee who moved there, but it's true the Irish in other cities. And this puts a brake on some of the nativist activity that we see in Wisconsin itself.
You mentioned the archivist who told you about the story. How did you go about doing the research?
How did I go about doing the research? Well, it actually did begin as a detective story. I started with the story of the rescue, and then I had to figure out what sources were available, which meant that I had to look at all of the people who were involved in the rescue, and then try to locate their papers all around the country. It took me to the National Archives of the Great Lakes region, which fortunately was in Chicago. Also took me to the National Archives in College Park, Maryland, right outside of Washington, D.C., the Library of Congress. There are actually papers that I could not get to that the U.S. District Attorney had, which are up in Sacramento. But I talked to the archivist about it, and it was all business papers. So I don't think anything was there that would have helped me, but I couldn't get to them at the time. From there, each question would push me into different kinds of sources. For instance, the fact that minstrelsy and Uncle Tom's Cabin were so important in formulating political rhetoric took me back into drama. And so I had to go start reading the actual adaptations of Stowe's Uncle Tom's Cabin. And by the way, how many people have read, I'm playing professor now, how many people have read Uncle Tom's Cabin? Study. And most of you probably know the story. It's not the story that you saw on the stage. This was not, the story that we really know as Uncle Tom's Cabin. It was more minstrel-like than it was positive. And there were tons of different adaptations. So I went and looked there as well. I had to read a lot of plays, and I had to read a lot of minstrel material. And that took me to libraries kind of very far afield. So it was everything from legal sources in the National Archives to newspaper sources to liturgies to sermons to plays. There are a lot of sources that end up going into it.
Yeah, that's one.
Okay. Yes.
Yeah, really, I am still asking the question why these people gathered to defend Dr. Glover. Because I'm wondering about their motivation. Like, did you find anything about their real motivation, whether they had their own stake in it?
That's the question being, what was the real motivation of the people who were there? Very difficult to pin down. You have abolitionists who believed without any qualification that slavery was evil and had to be abolished. That's a small group of the people who are there. You have another group of people, also abolitionists, who believed that you had to follow the Constitution, but that did not allow for the Fugitive Slave Act of 1850. So you have that abolitionist group. You then have a group of people that would probably constitute what we consider to be the middle, that everybody's always appealing to from either side. And the people in the middle were asked to make a very stark choice. And I think it's worth thinking about the choice they were asked to make, and think once again about political choices that maybe we are asked to make. On one side, you had the Democrats saying over and over again, union. We must follow what Congress did in passing the Fugitive Slave Act in order to save the Union. Without it, the Union is dead. We must follow the law. And on the other side, people said the Constitution and the rights enshrined have to be respected and protected. And that was what divides up that middle group. And in some states, the question is asked in many states across the North. In some of the states, we have clearly a unionist bent, and in others, people move more towards the protection of constitutional rights. That doesn't exactly explain how the Republicans come to power. In Wisconsin, though, it does. It's one of the few places where it's really an ideological battle. And it's the ideology that wins people over. And it's a question of protection of rights.